Any further, I want to ask the Spanish-speaking interpreter to come forward and to inquire as to whether there's anyone here at this point who would need the services of the Spanish-speaking interpreter, and if you do, to let this gentleman know. And also, the sign language interpreter is here as well, and if anyone needs the services of that interpreter, she will ask you the same now.
Buenas noches, señoras y señores, que alguno de los presentes necesita los servicios de intérprete en español o que tienen dificultades con el idioma inglés, por favor, levanten la mano o avísenos para darle el equipo que necesita. Y lo que está, no needs our service.
I'm going to ask you, sir, to stay for a while so that in case someone comes in later, you can check again. As well as the... Thank you. By way of background, Chief Justice Chase T. Rogers established the Commission to create a strategic plan to assist the judicial branch in its mission to resolve matters in a fair, timely, efficient, and open manner. The plan will be based on an examination of our state judicial system on such issues as physical and logistic accessibility of our courts, the fairness of treatment in all matters and to all people, and the efficiency and competence in judicial branch job performance. Such an examination would be incomplete without comments from the public. This public hearing is one of the ways for us to collect input from the public regarding our courts. We are also conducting a survey of some 500 individuals who have recently used the court system, and we have conducted approximately 80 focus groups of individuals who work within or regularly use the system. As for this evening, if you wish to speak and you have not yet signed up, please do so at the sign-up sheet located in the back of the courtroom. If you have made copies of your remarks as we have asked, would you please provide them to Melissa Farley? And she is this woman right here. We will be limiting our speakers to 5 minutes of testimony so that all interested persons will have the opportunity to speak and also to permit time for discussion among the Commission members. I would ask that speakers direct their comments to their recommendations for the strategic plan. If something is working, please tell us. If something needs improvement, we want to know that as well. And I am sure you are all aware, talking about particular cases is not within this Commission's purview. Before we get started, I want to thank you once again for coming out tonight on this wintry, blustery night to express your concerns, observations, and suggestions. And I would ask the Commission members who are here to come forward if they'd like to sit at the table. All right, the first individual who has signed up to speak tonight is Albert Lebrun. And I apologize ahead of time to all of you for if I mispronounce your names. Good evening.
Good evening. I'm here to tell you that the Godville Court performed extortion scheme. I've been fighting with that court for 17 years. I don't get anywhere. I was served with documents. My own lawyer told me that those documents were worthless, and with those worthless documents, they attached my home for $100,000. 5 years later, they gave me a trial. I lost because they stopped me. Anything I tried to do, they stopped me. And on June the 16th of this year, I almost lost my home because of that. An attachment of $100,000, a verdict of $90,000, a lien against my house for $90,000, a lien against my place of business for $90,000. I could not borrow money nowhere because of all this, and all this is done illegally. I could prove that to you. even because my own lawyer told me that the document I was served with were worthless. And then he decided to go along. He realized that the judge were in it and the other lawyer and all that, and he decided to go along with the whole thing. And that's where we are now. It's terrible what they could do to you. I need help. I need help very, very bad. For 17 years I've been fighting this thing. Right? So I wonder if you people, I could prove to you everything I say here, I could prove that to you. I got all the document. I've been copying for 2 days. I got a briefcase full of document there. I even got a case who went to Washington, D.C., the case of Door, guy from Maryland, and I learned a lot from that case because what they do, they attack you solid, and then they got you to capitulate to their extortion scheme. That case there showed that when a case goes to trial, the plaintiff wins 1.5% of the time. So I got also some document to show you that the prejudgment remedy statute is illegal because it's vague, and I am suggesting how to fix it. Right? And it's good. They know, the Commission knows since 1985, December of 1995, the statute has to be fixed, but they did nothing to fix it. So I'm suggesting to you, if you read the document I have prepared, you will see how this could be fixed. Okay? So if you want me to give you all those documents, I have them all with me.
Mr. LeBrun, you certainly can provide any written documents or testimony to, as I said, to Ms. Farley. You just give us a copy of what you want us to consider about your remarks this evening.
I'll give you the copy of everything I have, yes. Do I bring them to you there? The copy then?
We'll have someone get it from you, sir.
Thank you.
Thank you, Mr. LeBrun. The second speaker is Jane Russo.
Good evening. I put my views in letter form. I hope that's permitted. I didn't name any names for cases, but I kind of referenced certain issues that happened during the cases. And if you feel I'm getting lengthy, just cut me off here. I'm Jane Russo, mother of 2 college students, caregiver of 2 elderly parents, working in customer service, and a Christian. I'm a member of the False Allegation Solution Team based in Pennsylvania and a concerned citizen. For years I have watched the families of wrongfully convicted deplete their bank accounts, borrow money from friends and relatives, max out credit cards, and pay for lawyer services that didn't help them at all. Some are called criminals while they are actually victims of the justice system. Wrongfully convicted, they sit helplessly in prisons for years, while their appeals continually are delayed. The misjustice reeks of lies, cover-ups, and schemes to protect crooked police, judges, and those who set up these false allegations against them. Why do they falsely accuse someone, angry spouses, during or after divorce to gain custody of children, others for monetary gain, and those who just want to hurt someone? This crime against the innocent gets overlooked because there are so many true criminals that do commit these acts against others. What is there to do when a jury sits and listens to half the story, sees a signed confession because an accused person is scared, uneducated in the devices used in interrogation, and just wants to cooperate with the police, as we all been taught to do if you're any decent person? I have seen firsthand people wrongfully convicted of crimes they did not commit. What does this do to them and their families? I can expand, but I need to be concise. A person sits in a jail cell. His or her calls are listened to, shortened. Food is less than you would feed a dog. They sleep on steel beds with a stranger that may be a real derelict. If you're a true convict, maybe this wouldn't bother you. But would you want your sweet son or daughter mom or dad, relative that you love so much to have to be put in a compromising situation of danger, depression, and hopelessness. They lose their jobs at home, lose their reputation, because even if it's overturned, there are always those who say, maybe they did do it. How does this happen? The justice system. It used to be based on the burden of proof, or you were innocent until proven guilty. Now the police coerce the accused to confess with their forceful techniques and threats. The lawyers convince the accused to plea bargain, pleading guilty too for a lesser sentence, even when they're innocent. The judges have the authority to pick and choose that which will be used as evidence exhibits. They cover up the truth, suppress it from the jury so that the jury only sees bits and pieces of what they need to decide the fate of someone's life. Where there was supposed to be an interview of those who served on the jury, there are people that sometimes know the accused before they are biased. There are deals between judges and lawyers. It's not about truth anymore. If someone says they are innocent and there's valid evidence to prove it, all should be submitted to the jury for review. I've watched families miss once-in-a-lifetime events due to electronic monitoring or jail time, parent nights, football games, weddings, funerals of immediate family, even the loss of family members due to the stress involving the incarceration. Babies are born and grown up before the accused could even enjoy them. Seems like a small thing to those not involved, but to have to enjoy life in photographs and wait for commissary money to enjoy your birthday and not eat holiday meals that you used to prepare for your family or enjoy with the family, or even your church family, it hurts. It hurts everyone who loves these inmates because we know they're innocent. We talk to a deaf ear. No one answers our letters, and no one can help us because it's not their area. I know a woman that was caring for an elderly woman who allowed her to verbally take out a business loan for her to open a deli, and she was going to pay the woman back. The relatives came around and said that the woman was senile and that the caregiver had committed identity theft. The court would not allow the elderly woman to testify at the trial to state the truth. It was suppressed, and this caregiver remains in prison, awaiting an early release that was just blocked due to the Cheshire Home invasion, a horrid and criminal crime. Unlike this crime, the innocent are treated with the same sentence for crimes they did not commit. Please make our country a place to be proud of again. Listen to the hearts of people. Rehabilitate the real convicts as well. And make this one nation under God, indivisible with liberty and justice for all. I thank you for your time.
Thank you, Mr.
I'd like to add back to my letter. If I can read that, we can make it later.
Thank you very much. The third speaker is Joanne Leonard. Am I pronouncing that correctly? You just wait 1 minute, Mr. Leonard. Judge Mintz, do you want to sit up here?
Chief Justice Chase Rogers and committee members, I, Joanne Lenardi, former owner, operator of Joanne's and Kids Family Daycare, stand before you, a victim of the system we are here today to discuss. My innocent son, Frank, was wrongfully convicted of a crime he did not commit. He has been incarcerated for over 3.5 years and has been sentenced to 40 years, serving 20 concurrently on circumstantial evidence alone. I had no choice, because I own the daycare, to plead low no contendere because Frankie was already convicted. I'm on probation, and the DOC has not allowed me to see my son since March 16th of 2004. This was the result of a poorly handled case botched up by Officer Riley of the North Police Department because he failed to investigate anything, not even the families that attended my daycare. He took the easy way out by coercing a confession from an 18-year-old with a processing and speech delay disability that prevented him from understanding his Miranda rights. They wouldn't acknowledge that he was in special needs. That's a file from school. He didn't understand his Miranda rights, yet that fact was repeatedly ignored throughout the trial by the state prosecutor, Richard Colangelo, in a direct violation of the IDEA Act of 1973. The police needed to investigate the validity of the accusations and the credibility of the accusers, but did not. The girls had been examined and found to be intact. No signs of sexual abuse, yet they claimed being penetrated 1,200 to 1,800 times. The Department of Children and Family Services did their own investigation and concluded that the charges were unsubstantiated, but the judge did not allow the jury to hear that. But because of the coerced confession, the state went forward with the case. I feel my son's constitutional rights have been violated since the very beginning of this miscarriage of justice, which was allowed to spiral out of control. The coerced confession was on August 30th, and he wasn't booked until November, 3 months later. When Attorney Sherman asked the officer if he had a confession, why did he release him? Couldn't you have arrested him right then? The police officer said yes, but he had given him his word to let him go, but he signed a statement, so he let him go. That's a promise that is acknowledged in the appeal brief. This is the appeal we're waiting for as a bribe. The Innocent Project is reviewing our case. Problem with that is there was never any DNA because no crime was committed. The judge from the beginning of the trial treated Frankie as if he were guilty and referred to the girls as victims. This sends a signal to the jurors as to the outcome the judge expects. The DA prepped his prospective jurors by asking only one question. Could you convict a person with no evidence? If the prospective juror asked, what do you mean, no evidence? Of course there has to be evidence. The prosecutor, Mr. Colangelo, dismissed the juror. The medical records were not allowed in as exhibits, but referred to as showing no physical signs of abuse, yet she claimed it happened 1,200 to 1,800 times. The prosecution's key witness was not the doctor that examined the girls, but a nurse that gave a lecture complete with charts on how the hymen can be repaired, they can repair itself with the high levels of estrogen in young girls going through puberty. She said that the hymen rupturing from penetration was a myth, and it is actually a very elastic membrane that allows things to pass through it. This has been referred to as junk science by a pathologist, Dr. Friedlander, and he stated that the testimony should never have been allowed in court under Dahlberg. The other child claimed anal penetration 100 times, yet there was no signs of scar tissue or damage. The expert claimed that it wasn't unusual for there not to be any rupture because that is a place where things normally pass through and they had time to relax in anticipation. The list of inconsistencies were ignored as the DA was allowed to claim that their stories remained consistent in his closing argument. One of the jurors, Dr. Jose Neal, presented himself as a doctor from Greenwich, which in fact was a Norwalk doctor associated with the Norwalk Hospital where the accuser's mom worked for 20 years. Norwalk Hospital is not very large, and the nurses make it a point to know all the doctors. Frankie is awaiting an appeal which is based on actual innocence and ineffective counsel. The motion for an appeal was first entered on March 16th of 2004. Transcripts were due January 5th of 2005.
Ms. Leonard, you've used up your 5 minutes, and I see that you're reading from the material that you've given us, so I think if you would just...
Can I just say right now that Frankie has missed his graduation from college, the death of 2 grandfathers, the birth of 3 nephews, and he is about to spend his 4th birthday on December 8th, as well as the loving arms of his mother for 4 years due to the failed system and the corrupt justice that has overtaken factual truth. Sad thing is, cases are created for federal funding. Thank you.
Stephen Erickson.
Stephen with a B, an initial G, Erickson.
Good evening.
Okay. Would you like my
Yes.
I came to Connecticut in 1994. I bought a pet house and I later bought rental properties in Stafford Springs. Being a landlord, you need courts to work and you need police to work. If you don't have a business, you don't make any money. So I went to see elected officials and I started writing in the newspapers for, what I needed just to survive as a property owner. I proposed laws to elected officials, and I ended up being threatened by police to leave Connecticut or else. Having run cases through civil courts in Rockville, I ended up complaining about Judge Jonathan Kaplan. I tried to have him removed. I lodged complaints against Prosecutor Keith Currier, and the heat got more. So I ended up being attacked on my property like a home invasion, where I was mugged. I was told I'd be killed if I didn't turn over my wallet. I was attacked on my property. Only I was arrested, and the police would take no statements from my tenants, from me, and then committed perjury at court. My first day at court, Judge Jonathan Kaplan told me I was guilty and going to jail. It doesn't sound like it's been a fair trial. There's also a videotape that was played to the jury on how to find me guilty, but nothing about innocence or reasonable doubt. I had an attorney, Michael H. Agronoff, as my lawyer, and I told him to strike one of the jurors who was working for the police. So the work for the police became formal. So I was attacked on my property, so we started winning. So Michael H. Agronoff said he was called to the chambers by Judge Kaplan and told that he wasn't allowed to dispute the police or the prosecutor or defend him. So basically, I also found out from Attorney John O'Brien that Judge Kaplan will tell the attorney to win or lose a case or how it's going to end up. So for being attacked on my property, I was sentenced to a year in prison, 3 years probation, high fines. And I don't think anybody in the history of Connecticut has gotten a year in prison with no record for a self-serve and breach of peace. Breach of peace has to be in public, it's attacked on private property. I lost contact with my daughter. I wrote to her from jail. My entire family disowned me. I had a small business lost. If I want to get a place to live week to week, I have a criminal record. I can't load boxes on the Federal Express. I'm considered fine for most jobs I can't get, most apartments I can't get. I got a job down in New Orleans helping people after Katrina hit. I was making $2,600 after taxes per week as an insurance adjuster. I got all sorts of promotions. I changed the way video claims are done, because I showed the old brass how to do that. And I can't get a job now. I had to live out in the cold. I had no family. I had no income for 5 years. This is the type of damage that a rogue judge, rogue prosecutor, and police that commit perjury exact on so many people in Connecticut. If you do a word search on my name, Stephen with a V, middle initial G, Erickson, E-R-I-C-K-S-O-N, just in Google or in YouTube, I'm compiling this other victims of the courts, and it's going to be more than just one of us that's, this has happened to. We're finding that there's a pattern of abuse. And as far as ethics in the courts, if you can go to jail, prison, for being attacked on your own property, the judge knew that my life was threatened, that money was demanded from me. He also knew that my assailant, a felon, was given immunity for threatening life, threatening to kill me, and robbing me. And the individual came after me again and again, and it was just a joke to the police and the courts and the prosecutor.
Thank you, Mr. Erickson. Chris Kennedy.
My name is Chris Kennedy. I represent the Connecticut Civil Rights Council. I appreciate you all for coming out tonight. I was told that only an Irishman would wear shorts and a shirt in an ice storm, but that's all I had. Anyhow, the issues, essentially, my life has been consumed with litigation, defending myself and my family against retaliation by the court. I've given you a document about 10 pages long that illustrate about half of the issues. I guess the main problem that I see is that there's no accountability for judges in the judicial branch. There's no accountability for family relations officers. It's even difficult to state prosecutors. And that judges often will work with the prosecutors to settle a case. My initial introduction to the family court was, to the court was through the family court. My children were taken away from me, not for any abuse, but what I see is bias and discrimination against a person with a disability. I have attention deficit disorder, and the judge based his ruling in part on my disability, why he gave sole custody to the mother. And we ended our divorce with equality, joint custody, shared parenting, and a couple days later, the mother filed for sole custody with no changes in circumstances, and the judge gave it to her. Against every recommendation, the mother at the time was on trial for stabbing me and had a protective order in place that she continued to violate. And I don't understand how a court would do that. But this is Rockville Court. I'm hearing, this sounds like a theme here tonight. I wasn't allowed counsel. I told the judge, I talked to the Judicial Review Council, that I was entitled to an attorney for a contempt motion. And Judge Graziano's response was too bad. I saw bias against fathers, being held to varying incomes. What I saw is a pattern of abuse in the family court, and not just by this judge, but judges in general. There's a consistent bias against fathers in family court, and there is no accountability to the judges, and there's very little laws, and so the judge is free to do what he wants. Judge Carroll was my worst experience. He granted a restraining order against me with regards to my son, claiming I committed a violent, aggressive act based on an argument with my son. He went into my family, my Irish history, my religion. He said he had a case of a father just like me, and I was going to end up the same way as him. My parenting rules were stupid. He admitted to calling prosecutors in a pending case. I had a pending case in Enfield, and he admits to calling the state prosecutor and telling him not to nolly the case. I mean, how can a judge do that? This is the head of Rockville Court. He said that he's assuming that I'm guilty of a crime. I should be arrested. He asked where I lived. He said, well, the state police will take care of it because of where I live. He admitted to meeting with family relations. meeting with the other attorney, meeting with counsel privately. I mean, I thought that ex parte communication wasn't allowed, but apparently Rockville it's okay. And then the restraining order included the mother because of a computer error, which he refused to fix. It was brought to his attention by the clerk. They said, well, that's a computer problem. We can't get to it now, so I'm not going to do anything about it. And then what he did is he took that document, knowing it was false, drove it down to Hartford court, and gave it to the state prosecutor, telling them to have me arrested. And that was put into an arrest warrant affidavit and used to have me arrested. So here you have a judge committing a felony. I mean, the head of Rockville Court committing a felony by knowingly submitting false documents in an arrest warrant affidavit. And so I was arrested. The judge filed a complaint, and he issued a second restraining order against me, taking away my daughters. There's no allegation of abuse. There was no children even listed. I walk into court and ask why I'm being restrained, or who am I being restrained from? And he said, well, that's what the trial, or that's what the hearing will decide. Well, how did they take away my kids if he doesn't even know? And so, on and on. Judge Klazak meeting with family relations, calling the criminal courthouse, telling them to issue a protective order against me. Again, Rockville Court. Judge Graziani adding the mother to the restraining order. And then last January, he denies his involvement in front of the Judicial Committee at his reappointment. Here you have a judge lying under oath to the Judicial Committee, and they know it. And I guess the Judge Simon was perhaps the most colorful. I received a call the other night of a person saying, I'm sorry, I'll wrap it up, but he told the defendant that if he wanted his case dismissed, he would just stand on the bench and crow like a rooster, he'd dismiss the case. So he did. Or send some people with a violin, a good note for a good sentence, bad note for a bad sentence. And then just to wrap up, we talked about opening the courthouse. But at Rockville Court, I have 2 judicial complaints that have been sealed and added to my family court folder. They're sealed from the public, so it will bias anyone who reads my court folder. Only judges will see it. And so now they know I file complaints against judges. And so it goes on and on. I've given you the documents. And please review them, and some action needs to be taken, some accountability.
The next 2 speakers signed up, I believe, are no longer here. So the next one ready is Francis Niles. Tanisha. Tanisha.
I certainly, as a citizen, appreciate this fact that this commission is formed and that Connecticut does attest to wanting to reform its judicial system. And I think as we see a lot of the comments here today, there are severe problems with a lot of the procedures and ethics concerning the judges. My original brief here was actually based on rules that we need changed concerning what I have gathered as a producer doing a series called In the Interest of Justice. I see that to really talk about these rules where we need changes, it's going to take a much longer than 5 minutes. So I'm not going to really deal with them so much tonight as to talk about my own case. I do have a divorce case here in the state of Connecticut, and since that's what people are addressing tonight, that's what I'm going to testify to and submit later documents concerning that case. Now, in my case...
Well, sir, just to reiterate, I did say that we really aren't addressing particular cases, so if you want to stress instead what you think this commission should be looking at for its strategic plan, the commission members would certainly appreciate hearing that, since we cannot do anything about your individual case.
Okay, first of all, I think that you have to do all you can to create judges following the constitutionality of their rulings. Justice Gordon was very vocal about this, and as we well know, and there does seem to be a problem, as what I've been fighting for consistently in my case. In terms of, so I'm just going to go through some of these rules. In terms of legal assistance programs at courthouses, you should use competent employers who know how to construct every motion properly. My experience is that they don't, and that they don't know what the heck is going on. They understand some of the forms. They can't answer all the questions. As well, there's a notary public assigned by the state, and I had to go through a lot of harangue and deal with the administrative assistant of the courts to finally tell this notary that he must notarize all documents and not just documents concerning the forms. I think I did actually create that change, so I'm happy to see that, but it should be written into the rules. I think we have to have a re-examination, especially by the Judicial Review Council, on exactly what misconduct should be. As a matter of fact, I'm following this misconduct issue on a local, state, and national forum concerning the Judicial Conference, on the national forum, dealing with the judiciary committees at both the House and the Senate. And if you want to know more about that, please go online and go to YouTube and look up "In the Interest of Justice," and you will find my testimony given to the Judicial Conference concerning all those points. Now, I will have to say that in my case, when I went to the Judicial Review Council and I told them that the Supreme Court panel denied and dismissed my case because they didn't think that my mother being hit by a car was just cause to file a motion late, so the whole thing is dismissed. My family tells me that my mother's going to not live the weekend and that I must leave immediately. I put in a motion to file late, and this was denied. But this is an unethical question. This is, as far as the Judicial Review Council is concerned, so what? The judge has his discretion. I think we have to re-examine what misconduct is. And I'll talk more, I'll send you more material later about that. This whole idea about up at the appellate court that you need 16 copies is extremely burdensome, especially in this electronic age, where we can provide 1 copy or 3 copies or even 6 copies. But why does the appellate court need 16 copies? That is so burdensome for the average pro se defendant, and especially if we can provide a disc that all the judges and the clerks have access to, and it's online. There's no reason for that these days. Furthermore, understand it's a system that lawyers can submit motions and all sorts of online, all sorts of legal maneuvers online. And I've been asking the court administration for years now, for 3 years, that it's time to make that same access to the pro se defendants. As I say, I didn't even touch a lot of these points. I do read them, and I've submitted them before. But if I had 10 more seconds here, I'd say that writ severe must be returned to the judiciary. This is very important. That strict scrutiny must be abided by. You can't just dismiss a case when strict scrutiny was asked for by the court. To prove it's strict scrutiny, under strict scrutiny, it's least restrictive remedy to violating a fundamental right. We need that.
You've provided these written comments
I
and
thank
made
you
copies of them. Thank you very much. Joe Leslie.
As stated in the press release from the Judicial Branch's External Affairs Division on the Judicial Branch website, one of the tasks of the Commission in creating a strategic plan that addresses those needs is to examine public perceptions of our state judicial system. It is to that end that I offer my perception and a list of things that form that form that perception. My perception comes from successfully defending myself pro se against a wrongful foreclosure action brought in 2004, and coincidentally in Rockford. The reason that I was pro se is that after talking with scores of lawyers, I couldn't find any that would say anything other than there's no defense to a foreclosure. And that will help you get the best deal, we'll watch the process for you, we'll stall. But it was a wrongful foreclosure that I really felt that I had wanted to protect my rights as a consumer, and I couldn't find anybody that could help me. My constitutionally protected opinion and perception, a perception I believe is shared by the majority of folks that are defendants in foreclosure actions, is that the judicial system is all too eager to do the work of the banks for them. I believe that the two most worst manifestations of this perception is that very few people do defend themselves in foreclosure actions. And there are very few lawyers, if any, and again, I haven't met any yet, that either think there are defenses to a foreclosure or know what to do. The first perception that I have, and moving away from my notes because somebody mentioned the clerk's office. The Rockville clerk's office, being the first perception you get of a court, is horrendous. They make you sit there and ring a bell. If you're an attorney, they'll wait on you right away. They generally know the attorneys, but you can die of old age if you're a pro se or a defendant, a regular defendant sitting there. It's almost humiliating having to ring a bell and just wait there while they look at you through the glass for sometimes 15, 20 minutes. Beyond that, the next perception that you're faced with is really the perception of the court towards you, as in my case, a pro se litigant. Usually, you have to climb the hurdle of, you're ignorant to the rules, to the laws, you're guilty for the claims of the plaintiff, and you're without defenses. It's a huge hurdle to get over because you feel, again, the perception at least, that the court is biased towards you because you're being defended. I understand the economics of foreclosure and the business of lawyering, so I can't say I don't understand why a lot of lawyers don't know how to defend a foreclosure action. If you're a lawyer and you want to make some money, which I think is fine, would you rather represent a bank who's going to give you 20 or 30 foreclosure cases a month, cookie cutter deals that you just walk in and get a slam dunk? Or would you rather have to first go find your customer every time and then listen to probably 20 or 30 hours worth of sob story and then hope there's some kind of defense and hope that the defendant has some money, which is typically not the case because they're usually debtors in a foreclosure action. The banks offer steady business. Again, the time of defending versus prosecuting would be a big hurdle to do business as a defending debtors, homeowners. Because defendants don't defend themselves that much, the courts seem to do whatever plaintiffs ask without scrutinizing the file. Again, a generalization of perception. And that is that nobody's there to kind of raise their hand and say, wait a minute, there's no no. Wait a minute, the complaint says that X bank is the plaintiff, whereas the note says another bank is and there's no assignment. Who's standing before this court? Connecticut is unique in that it's a strict foreclosure state. Yes, a creature of the legislative branch, perhaps, but again, we're talking perception. And I believe that the perception is that, again, our system as a whole is on the side of the banks to foreclose very quickly with no regard or little regard to the plaintiffs, the defendant's rights.
Thank you, Mr. Wilson. Margaret Levy.
It's my concern that the money bail system as it operates in Connecticut is a disaster. The failures of the money bail system must be addressed within the next few years. The system is long overdue for change. Racial disparity in the jails and prisons is due in significant measure to economic disparity among racial groups in Connecticut. Poverty limits the ability of minority defendants to make money. My caseload consists exclusively of special public defender representation in state courts and court appointments in the federal courts. By definition, my clients are indigent. They cannot afford a private lawyer. They can rarely afford bail. Setting bail at a particular level for all defendants charged with a given crime may sound fair. However, it serves to detain defendants who have little money available. On paper, Connecticut's bail system looks flexible. However, reading the practice book, Chapter 38 refers to pretrial release, gives no sense whatsoever of the way the system actually operates. Several years ago, a judge of the Superior Court here in Hartford set bail for one of my clients at $300,000. That is a substantial sum. But a person with property may be able to post real estate, cash in an insurance policy, or perhaps take a loan from a credit union. My client had the nerve to tell the judge, "I'm just an ordinary guy from the north end of Hartford. There is no way my family can put up $300,000. My client had been found indigent and eligible for court-appointed lawyer. No one ever questioned that finding. He was just plain out of luck, the way lots of other defendants are, because the court system does not take into consideration his financial situation." Just one other example. A couple of years ago, I had a client who was 16. He was being raised by a drug-addicted single mother. She'd been evicted from her apartment a few days before the court hearing. He'd never met his father. The charge was attempted larceny. It was my client's first charge in adult court. We explained to the judge that the $100,000 bond he proposed would effectively detain the child without bail. It did. After several months, the client gave up fighting the legal aspects of his case. He pled guilty just to get rid of the case. He needlessly obtained a felony criminal record, which he could likely have avoided by making a reasonable bail, had one been set, or had reasonable conditions been set. This young man, more than any other client I've ever had, sincerely wanted to get out of jail to go to school. The Hartford public school system was willing to take him back. He asked the counselors at Manson Youth Institution whether he'd be permitted to attend both the morning and afternoon educational sessions there, even though they were the same, covering the same material, because he so much wanted to be exposed to teachers, be able to have access to education. Instead, he copped out. Rather than being able to be released on some bond, to live with relatives who showed up in court explaining that they were prepared to take him into their homes. The injustices of the bail system really deserve the attention of this commission. The bail system must be reformed. There's got to be a better way of dealing with individuals who are presumed to be innocent. Thank you.
David Silka?
the way I would phrase it more generally is, urge you to investigate the issue of for-profit supervision. In my divorce agreement in 2005, I agreed to limited set of supervised visits because my ex-wife really insisted on it. And a guy was appointed to be quote-unquote the gatekeeper who was going to transition me to a unsupervised relationship with my children as soon as possible. Well, when the supervisor, after many, many months, I was told it would be about a dozen sessions that I would prove myself that I didn't need supervision. Started writing that it wasn't necessary, I was a great guy and all that. First of all, he allowed my ex-wife's attorney completely bent his ear to changing his recommendation. The gatekeeper did nothing. Instead, just continuing. The guardian ad litem as well just turned a blind eye. Since then, my divorce and actual supervision started before. I spent $1.5 million on supervision and divorce. Whenever anyone sends an email because they hate people, which is $150 an hour, I think my children are being essentially lost. And when I hired Attorney Patterson who took the case because he said he never had anything like it, this same gatekeeper cancelled my right to see my kids. I haven't seen this suspect. He basically retaliated against my children and me. Just to give you an idea of what the supervisor said when he was recommending that it end, I do want to read this because it just shows you how crazy this thing is. He wrote to everybody, "I can truly say that I've not often seen this type of connection between the father," and that was his emphasis, "and his children that I see in David when he's with Chloe and Jake. I wish that I could have had that connection with any one of my own crew, by which he means his adopted children." Within a week, the gatekeeper and the guardian ad litem had commented about clandestine meetings between my ex-wife's attorney and the supervisor that should not be happening. Clandestine meetings is what the gatekeeper called them. Totally changed his opinion. Nobody questioned his change of opinion. I told you about the money since then. And then this brazen retaliation against me and my children. When I hired an attorney, I'd like to just give you the data point about that too, because it's also, I think, instructive. It seems as if there was communication between the attorney and the gatekeeper the very day that he cancelled my visits. His records show that they were talking. We believe that she told him, "Hey, Patterson, sue everyone, careful." He asked to be indemnified. 3 minutes after he asked to be indemnified, the ex-wife's attorney indemnified him. Clearly there was, I don't think that's a coincidence, nor does Attorney Patterson. When we refused to indemnify him, that's when he cancelled the business. There's a racket going on. Children are being held hostage to a great train of supervisors, gatekeepers, guardian ad litems, child therapists. I'd just like to mention one thing. My wife, I believe my ex-wife's intention is to completely cut the relationship between me and my children, to remarry and so forth. When my mother, who we have a very close family, I've been to all my cousins' weddings and so forth. When my mum wanted to see her kids this summer, the children's therapist said she could see her grandchildren if she didn't mention me or any of their cousins or show any pictures of any family members. I have a sister and 7 brothers and sisters. She wasn't allowed to show any pictures or even mention any of the children's cousins or their father. And that was the condition of her seeing her grandchildren. It's disgusting. It's completely disgusting. I would love one of you to take up my case. I heard that you come in investigate cases, but I'm doing my best not to investigate cases. I want to see my kids. I was denied seeing them last weekend. Again, the email sent by the gatekeeper, he's still in the case. He CC'd 8 people, to know that I can't see my kids. It's just disgusting. The whole for-profit thing is totally compromised. It's sick. And people who are suffering like people are my children, as well as me, but no one seems to care much about fathers. But at least the children, and I hope you guys will care. Thanks.
Thank you. The next person signed up was withdrawn her name, Bill Mulvey.